Hello everyone, today I'll be sharing another legal story with you. So what happened on 18 September 2025 is that the Supreme Court was dealing with the case of Amanjot Singh Chadda versus the Union of India and others. Okay, so while dealing with this case, basically a writ petition was filed in this case by Amanjot Singh, right? And the writ petition highlighted the difficulties that were faced by the Sikh couple regarding the registration of their marriage due to the non-implementation of law, right? So due to non-implementation of rules, they face difficulties in registration of their marriage, right? So some states have framed rules regarding the registration of marriage, but many states had not, and this is creating a discriminatory patchwork, and their ability, the couple's ability or Sikh couple's ability to prove marriage depends upon the postal code. So basically this means that the certain states, so the postal codes in those states which have framed rules, right, can register the couple living in those postal codes can register their marriage, right, because those states have framed the rules regarding that. But certain states which do not frame rules, the people living in those postal codes, they cannot register their marriage. So this is creating a discriminatory patchwork where certain states, the Sikh couple living in certain states can register their marriage while the other cannot, right? The court on in this case, they emphasized on section 6 of Anand Marriage Act. So this section 6 of Anand Marriage Act, it imposes a statutory duty, right, a mandatory statutory duty on the states to create a mechanism for registration of Sikh marriages that were performed as per the Anand Kara ceremony. So Sikh marriages are performed as per the Anand Kara ceremony, and this section 6 of this Anand Marriage Act, it imposes a compulsory duty on the states to frame rules regarding the registration, right? And since it is a mandatory duty, it rejected the argument that it is discretionary and depends upon the size of Sikh population. So the respondents' argument that it is discretionary to frame rules regarding the registration of marriage, it has been rejected by the Supreme Court, since because it is a mandatory statutory duty and it is not discretionary. Okay, the court in this case also clarified that non-registration of marriage will not invalidate it, right? The marriage will still remain valid, okay, and but in case of certain rights, in order to secure certain rights, marriage certificate plays an important role, like right. So in order to secure rights such as maintenance, inheritance, succession, in such cases marriage certificate plays important role, because it is easier to prove marriage in such cases, right? So it helps in securing certain rights. Okay, Supreme Court said that in a country like India, where there is a secular framework, right, which respect each other's religion identity, right? So this, because we have a secular framework, we respect every religion, and the people following that religion, having that religious identity, we respect different religious identity in this country, right? At the same time, we are ensuring civic equality among the people having different religious identity, right? So the Supreme Court is saying that since India is having a secular framework and we respect every religious identity, at the same time we ensure that civic equality is maintained among the people of different religious identity. The law must provide a neutral workable route by which the marriage solemnized by Anand Karaj are recorded and certified on the same footing as other marriages. So the Sikh marriages that are performed through the ceremony of Anand Karaj, they are certified and recorded in the same footing as the other marriages are recorded in different religions, right? So the way they are recorded, we record the marriage that are performed through Anand Karaj too in the same way. Okay, Supreme Court in this case directed the 17 states, okay, and 7 UTs to frame rules for registration of Sikh marriage under Anand Marriage Act 1909 within 4 months. So Supreme Court gave a timeline of 4 months for framing rules, And Supreme Court also said that until the rules are framed, the states and the UTs are required to immediately register marriages under the that are performed through Anand Karaj, right? They have to be recorded under Special Marriage Act till the time the rules are not framed. So within the period of this 4 month that the court has given for the framing of rules, till the time the rules are not framed, they are directed, the states and UTs are directed that they can record the marriages under the Special Marriage Act. One thing the Supreme Court said, that if the couple put an emphasis, right, in the certificate, in the marriages that they are registered under the Special Marriage Act till the time the rules are not framed, so in that case, if the couple emphasize, then there specifically it can be written that the marriage has been performed through Anand Karaj ceremony, if the couple emphasize on it. Okay, this is what happened in this case. Thank you so much.